The next session, it is my pleasure to introduce Leland Frost. Mr. Frost is the Associate General Counsel for the National Association of Manufacturers, which is NAM, N-A-M. He also serves as Director of the Manufacturers Compliance Institute, which provides training and assistance on state, national, and indeed global business issues. Mr. Frost's background includes international, environmental, and corporate law experience based on time at multiple law firms and at working for a federal judge and the Alabama Attorney General. Please join me in welcoming Mr. Leland Frost.
Well, thank you very much, David, for that kind introduction. I certainly don't need to be called Mr., but I appreciate it nonetheless. So I've got a pretty long presentation here, and I also tend to talk fast, which is kind of a bad combination. But I will try to slow it down here for you all. And just so you know, the Montana Chamber of Commerce is actually our state partner here in Montana, and we have been very privileged to work with them over the years and very thankful for all of their leadership. And you all are lucky to have them too. They do a lot of great work, and it has been great to get to know Webb and Bridger and hear all about the fantastic things they're doing. So just a little bit, I'm going to talk generally about who we are and what we do, kind of global trends and why they matter to Montana, and then a little bit too about some case studies of issues we've worked on, and then finally how we're fighting back. And that gets a little more exciting there toward the end. So who we are. We actually were founded in 1895 in Cincinnati, Ohio. We were actually then later helped found the Chamber of Commerce, and they have since grown a lot bigger than us, but we represent more than 12 million men and women and have more than 14,000 members, which represents over 85% of U.S. industrial output. And a little bit more about the MCLA, or the Manufacturers Center for Legal Action. We have a huge policy team at the NAM of 20 or 30 people, and then a legal team of about 6, and we work closely with that policy team to achieve the goals that matter to our members and to manufacturers. We engage in party litigation, and we also provide friend of the court or amicus brief support in key cases. We've got about 80 active cases right now. And in addition, we provide compliance assistance and training to our member companies. And we really have a manufacturing-focused litigation strategy. And I'll talk more about the work the MCLA is doing later on. So kind of our 6 main issue areas here: environmental, labor, product liability, intellectual property, corporate governance, and trade. We also have a very broad portfolio even beyond that. Everything from taxes to free speech. There's a lot that impacts manufacturing nowadays. So why does manufacturing and why do global trends matter to Montana? And I think this chart here, if you can see it, kind of helps point that out. Total output for manufacturing was $3.6 billion in 2016 in Montana, which accounts for 7.9% of the total output in the state and employs 4.2% of the workforce. In addition, roughly 20,000 manufacturing employees in Montana in 2016, and their average annual compensation was $50,000, which is well above the average here in Montana, and we're very proud of that. And those are not small numbers. This compensation is far better than for general business, and it's growing. And the one thing, too, that I think a lot of people maybe don't think about as often as they should is Montana is a big export state. A lot of the products made here in Montana are sold not only out of the state, but out of the country. Over $1 billion in manufactured goods were exported in 2016. This helps create jobs in the state, and 23% of manufacturers in Montana helped employ people through those exports. And also, if you look at the bottom right, you'll see Canada and China, and those are huge export markets for Montana. And I'll talk a little bit about that later and why those matters and the changes that are happening there and why you all should be following that. So now to the good stuff, right? what is going right, what is working in DC. And I've got one whole slide on this, so there's a lot to talk about there. The NAM has been doing a survey for over 20 years about where manufacturers stand on their outlook on the economy. And at the end of 2017, we polled them again, and 94% said that they were positive about their company's outlook, which is by far the highest in the 20-year survey. And as Harold mentioned, we have a new Supreme Court Justice, Justice Neil Gorsuch, which is a huge win. And also, for those of you who follow the trade press, there are rumors we might get another justice here this summer. We'll see where that goes. And then also the Congressional Review Act, which has not really been used in the past. The last time it was used was in 2001 to overturn the so-called ergonomics rule. But when President Trump came in, he worked with Congress to push 15 rules through the CRA, which might not sound like a lot, but there are a couple slides coming up that will show you the huge impact that those rules could have had and why that is so important. And these were mainly midnight regulations that came out in 2016 under President Obama. And importantly, the CRA provides that a rule may not be issued in the future in substantially the same form, which prevents those agencies from trying to pass those rules again unless Congress acts. And also, President Trump's executive order, the 2-for-1, as Harold was talking about. There's a challenge to that that's ongoing in the district court for DC, but the judge there recently ruled that the plaintiffs have failed to meet their burden of plausibly challenging that, so that's pretty good, but it sounds like they are going to likely to seek to continue suing on that. Just one more number here. Under the 2-for-1, across the federal government, roughly 1,600 regulatory actions have been withdrawn, delayed, or made inactive, which that's a huge win. When is the last time you heard about DC undoing regulations or withdrawing regulations? You just don't hear about that happening, and we're really glad to hear those kind of numbers coming out of DC. So the bad and the ugly and everything else, right? This is the part you've been waiting for. This is kind of where things are going wrong and where we can make positive changes. And I'm going to start kind of globally and then work my way down from there, federal and then to state issues as well. And as you all likely know, where global and federal institutions fail to act or fail to act timely, the states will act or private parties will act, and they step up and they sue and they create more litigation where the federal government has not spoken clearly. And that perceived lack of regulatory action leads to more NGO lawsuits for product liability, public nuisance, public trust, a lot of the climate change cases in California and New York that we've been talking about, and I'm sure you all will hear more about today as well. And President Trump and everyone who's in Washington can change a lot of what they're doing, but they've got to change it using the right process. For those of you who are attorneys and who follow federal policies, you'll know that the APA, the Administrative Procedure Act, requires notice and comment to amend rules, and we have seen, at least the past year, them having a very hard time following through with that APA process correctly, which then opens up all those great legal reforms to challenges. And there are more lawsuits popping up than anyone can really track right now. And a way to help solve that is by making sure that we're going through the proper process when we're undoing all of those regulations. So kind of global issues here. We start with Canada. And for those of you who might not know, Canada is obviously our neighbor to the north, but but the part you might not know is that they have really terrible patent protections, and no one thinks about that, but we sell a lot of products there, and they, over the last few years, have revoked over 22 pharmaceutical patents, and that is huge. Pharmaceuticals are a big market here in the US, and we sell them and produce them in Canada, and they cross the borders, but when you're not protecting those IP rights, you cannot be successful as a business. And I just want to talk about briefly one case we were involved with, Eli Lilly and Co. v. Canada. Eli Lilly actually brought an investment treaty dispute under NAFTA, which that'll become relevant later on, and I'm sure you've all seen the debates going on right now about NAFTA and what that means, but under NAFTA, Eli Lilly was actually able to challenge Canada for taking their patent rights under the Promised Utility Doctrine. And Eli Lilly lost, But the next case the Canada Supreme Court heard in 2017, they overturned that promised utility doctrine. And Canada is getting better, but lack of investor-state dispute settlements in the next version of NAFTA that's been proposed could really hamper that and prevent U.S. companies from challenging Canada when it takes away those patent rights. And then also recently argued in the U.S. Supreme Court is Microsoft v. Department of Justice, which deals with search warrants for data stored abroad. So in this case, Microsoft was storing a client's data on servers in Ireland, and the U.S. government issued them a warrant seeking to get access to that data. But typically there are treaties on this, and there's precedent when data is stored abroad in a hard copy, the U.S. can't just issue a warrant to get that. They've got to go through the proper channels, through the foreign country to get access to that information. But the problem here is that this was digital. This was just stored on a server. And so can they get access to that data without going through the proper channels? And this is interesting because if we're doing this to foreign countries, it then opens the avenue for them to do it to us, right? And how many people want Russia and China telling companies that have data stored in the US they have to turn it over to those governments? No one wants that to happen. And this is a huge issue that could break down that treaty process that has traditionally kept a lot of that information private and secured. And then finally, there's a case right now in the European Commission about confidential business information. And it involves a massive amount of public disclosure of confidential business information relating to pesticides used in both the US and Europe, including how products are manufactured and their formulation. And this obviously has broad implications, not only for crop protection, but also for all US chemical manufacturers operating around the world. So if this would be essentially a website in Europe that discloses your manufacturing process and all the chemicals you're using in that process. So what does that mean, right? If that is now public information, we know China is not going to hesitate to take that and start producing the products themselves. And this is very different than something like a copyright or a patent. When you've got CBI, that's much harder to defend in the courts once it gets out there. I think the classic is Coca-Cola's secret formula, right? It's not patented, there's no copyright, but it is a closely held business secret that they would never want to be on some public website. And obviously, Chinese copyright infringement is an ongoing issue too, but there's been a lot of great positive movement in that area as well. So what to watch for next? And I highlight these things not because this is the whole universe that's out there. There's a lot that's going on, but I'm highlighting these because you probably haven't heard of most of these. And they actually really do matter, and they could end up with you being sued or with your products being confiscated in foreign markets if you're selling abroad. And one that's coming up here soon is the GDPR, the General Data Protection Regulation, which is in Europe and provides for strengthened data protection for EU individuals. So if you're a company in Montana and you sell a widget to Germany, well, you're going to collect their address, their name, their email, probably their credit card information too. And if you're doing that, you need to be complying with the GDPR and how Europe wants you to protect their citizens' data. And then also, a couple of these have flown under the radar over the years too, but Russia and China have similar laws, and they're really even more draconian in that they can kind of choose what and who they want their information stored in those countries. So example for China, people who are selling network products and even just services into China are required to localize that data in China. And most people would never think about that, right? You sell your product on the web, it gets shipped, you're done with it. But no, you've got to then think about what you're doing with that data that you have collected. And obviously there's a lot of trade issues. I won't really get into those, but like I said, NAFTA is big. Brexit is big because we're going to have to renegotiate trade treaties with the UK under Brexit when it goes through. And there were obviously some major tariffs passed here recently that affect lots of companies, and we'll see where that goes. We're continuing to fight on all of those fronts. So with that kind of global picture in mind, how does that affect the federal government? Where does that get us? And really, one of the most recent cases that is a good indicator of that is WOTUS, or Waters of the United States. And I'm sure many of you have heard of that. The kind of baseline that is used is there's a farmer, he planted trees on his property to keep the water from running off, and then because he planted trees, there's now kind of a divot in the land and a pond when it rains, and the federal government comes in and says, no, you can no longer farm on your land because there's water that puddles on your property. And so we have been challenging that for years, and you've probably read the news. There's lots of companies that have been attacked, lots of even small businesses and farmers that have been attacked over that. But the case that got to the Supreme Court was purely on jurisdiction at this point, whether those challenges to that regulation should be heard in district courts or in circuit appellate courts. And the Supreme Court actually ruled 9-0 in our favor, which does not happen very often, that that should be in the district court. But because of that, the NGOs are now filing suit all across the country. There's lawsuits in New York, there's lawsuits in South Carolina, and that makes it really difficult. We're trying to combine all of those into one lawsuit in Texas, but the federal government right now, as they're still getting their act together, they have issued a notice to withdraw the 2015 rule, which that is also now being challenged on the procedure that they used to follow through with that. So kind of hearkening back to my earlier comments, if the federal government is not using the right process, they're going to be sued and challenged on what they are doing. And just two more specific examples on this. One is the Consumer Product Safety Commission's new rule on phthalates, and most of you have probably never heard of phthalates. But phthalates are in almost every rubber plastic product you use. The kind of classic is the bathtub duck, right? It's vinyl, it's flexible. Phthalates are in that to keep it flexible, and there are some special interest groups that forced the CSPC to issue a new regulation on phthalates, and that new regulation has now banned the phthalate DINP, which was used in all of those products. But the problem is the CSPC, again, this was back in 2016 under President Obama, they did not go through the right process to do that. They were not relying on science, they didn't have the right voting mechanisms in place. And really, if you look at the science, there is no demonstrable risk from those phthalates. None has ever been proven, not even in Europe, not in Canada. And so it's really a slippery slope for chemicals generally when you have agencies that are going through unfounded processes to issue rules for just special interest groups. And that's kind of a huge breakdown that we are fighting back against. And that overlaps kind of with TSCA, which is the Toxic Substances Control Act. Again, most of you probably have not heard of TSCA, but it regulates chemicals that are produced, manufactured, consumed across the country. And a new TSCA called the Lautenberg Act actually came out back in 2016 as well. But what was unique about that is everyone was on the same page. Sierra Club, NRDC, manufacturers, everyone liked the rule that came out. But now that those NGOs are smelling blood in the water, they're attacking that too. And they have filed 5 lawsuits so far claiming that it didn't go far enough, even though just a couple years ago they said they thought it was great and they were very happy with it. And so, you know, where that leads to is that there's so many lawsuits out there, you have to kind of pick and choose where you're going to fight back, and you've got to cull your resources because there's just too much. And let me now move kind of to a different department of the government, so the Department of Labor and OSHA. So many of those regulations that came out have been stayed, but there's still a lot of uncertainty as to where that is going. Under the injury and illness reporting, which you may have heard as the anti-drug testing, part of that has actually gone into effect, even though there are lawsuits holding that in abeyance. The reporting date went into effect on December 15th, but we're actually expecting a new rule here soon. And then also silica, something many of you probably have not heard about as well, but it's, yes, I see some smiles out there. Silica really matters to people who are in foundries, doing mining, doing construction. So it's basically just dust and dirt that you breathe in. There's an old standard that's out there that's been very successful for years, but groups challenged that. They weren't happy with it. And the DC Circuit actually ruled against us on December 22nd and has sent it back to the agency to look at that more. But that outcome has billions of dollars in impacts and could shut down a lot of businesses from mines to foundries. And so we'll see where that ends up, but we're glad that they're at least considering the arguments that we've put forth there. And so where does that get us? Well, just looking at the labor regulations, right, this is what we were facing at the end of 2016. Over $80 billion and almost 400 million hours of compliance for these regulations. So blacklisting never came out, but this is just a simple overview of what we were facing, and almost all of this has been rolled back. Like I said, silica we're still having problems with. But this is significant. These are huge changes, huge reforms going on in DC right now. And so this is just a different graph to kind of show you the huge uptick of those midnight regulations at the end of 2016. That is a huge change that came in that we fortunately were able to fight back and stop a lot of it. So what's next? What to watch for next? Well, DOJ and EPA have announced very publicly, they're using it as part of their campaigns and their platforms, that they're going to be doing more enforcement. And you've already seen that with opioids and things like that. And EPA has ramped up its Superfund efforts. So they are targeting lots of companies out there. And for those of you who don't know, Superfund is a federal government program designed to fund the cleanup of sites contaminated with hazardous substances. It actually came out under the CERCLA, the Comprehensive Environmental Response Compensation and Liability Act of 1980. And a lot of those sites have been addressed over the years. There are some that have been ongoing now for close to 40 years and still haven't been cleaned up. But this is something that Administrator Pruitt has taken on personally, and he is overseeing these. And we've seen companies from California to New Jersey to Tennessee. They are getting sued over this, and a lot of these are small companies too that have had settlements in place previously, and now as a part of this new campaign, they're going after them. So one, just as an example for you all, is a small DoD contractor in Tennessee, small family-owned company that has made grenades for the DoD since World War I. So they've helped us win multiple world wars, and other people who were on property nearby were using hazardous chemicals that have now flooded through the water stream onto their property. And the DoD and the EPA are trying to hold them accountable to clean up for that, which would not only bankrupt this small family-owned company, but is also not in the best interest of the government or the people. And so things like that are spreading, and despite the fact that we're seeing lots of good regulatory reform, there are issues out there to watch out for too, and such as the Clean Power Plan. So proposed comments to that are due in April this year, and there's a lot too on class action waivers and arbitration challenges, such as the recent Supreme Court case NLRB v. Murphy Oil, which is class action waivers and arbitration. And this matters for anyone who employs multiple people and uses a pre-dispute arbitration agreement in their class action waivers. That's a fairly common thing for you to have in your contract with people that you hire to keep costs down, to make it more time effective, and typically the outcomes are better for both parties regardless. But there are a lot of special interest groups and unions that don't like those type of contracts, and they're challenging them. And for those who are DC insiders, you might even know there's been a lot of change on the NLRB, the National Labor Relations Board here too, which decides a lot of those DOL challenges. And late last year, they reversed several important issues in our favor, in the business community's favor, but they have now kind of under the table been challenged through Democrats and are having to reverse some of those positive opinions here. Just last week, the Browning-Ferris Joint Employer Standard was re-implemented after having been overturned in November. So, and then finally to state issues and why all of this matters for you in Montana. And let me just start with infrastructure. So pipelines, natural gas, power plants, all of that is being attacked under multiple federal statutes, such as the Clean Water Act, eminent domain, under the Federal Energy Regulatory Commission, and for climate change impacts. And this is a huge problem. So for upstate New York, there is a pipeline called Constitution Pipeline that was trying to get natural gas not only to homes, but to manufacturers who could use it and provide jobs. And it has been blocked again and again by New York State. And so now those factories are moving elsewhere, and they are not able to provide those jobs, they're not able to produce those products. And people often don't think about it, but natural gas is used in a lot of things, from producing glass to producing drugs, lots of really beneficial products that people need that they're not being able to get access to because states are blocking these. And there are tens of millions of dollars behind these NGOs, and they've even in one case they have law school students who are volunteering to help them with their lawsuits to do doc reviews. So it's kind of hard to stand up against a whole law school class of kids, but we're working on it. And then again, too, kind of the similar themes here. There's a lot of product liability, public nuisance, public trust theories of causation. One that's been fun to watch, I jokingly say fun, out in California is on sugar beverages. They now want you to post on these sugared beverages on your advertisements a huge 20% of the ad that says sugar is bad for you, this can cause harms, this can cause obesity, and that's being sued. There's also a cell phone case now in California too, where they want you to, on your cell phone advertisements on your products, to say that cell phones have radiation is bad for you. And none of this has been scientifically proven. I mean, obviously we know sugar can cause obesity, but these are not valid claims, and these go against your First Amendment basic free speech principles to have you marketing against your own product on your labeling. And again, there's a lot in California right now on overtime and minimum wage laws. There was a case recently, just March 5th, 2018, that came down in California that okayed the state's more generous overtime pay formula. So historically, there's a federal overtime pay formula. You comply with that, you're fine regardless of what state you're working in. But now if you have workers in California, you've got to comply with that overtime pay standard and calculate it separately from the rest of your workers. So if you're not doing that, you're going to get sued when you have workers in California. And what's next? What are we watching for here? And really, like I said, all these opposition groups are so well funded. They've raised tens of millions, hundreds of millions of dollars to file these lawsuits across the country, from California to New York. And it's hard to push back against all of those without a concerted business effort from the states through to the federal and national groups. And typically these suits are motivated by deep pocket jurisprudence, where manufacturers are named because they are the perceived deep pocket, or regulation through litigation, where policy advocates use the tort system to regulate products. And 2018 really is going to provide an important gauge of where this is going forward and whether we can stop some of these challenges or not. And again, just as updates for all of you, so for the businesses who are here, you probably have to comply with Prop 65 when you're selling products to California. Well, if you missed it, there's a new Prop 65 coming out August 30th that you've got to now comply with those new labeling requirements. And not only do you have to have those labels on the product, if you're selling them online, you've got to have those labels on your website too. So think about like Amazon and all the products that it sells. It now has to figure out how to post all these warning labels that comply with Prop 65 in Europe and wherever else it does business on its website. And that is not an easy thing to do. We're also seeing a lot more state and local employment law issues and predictive scheduling and burdensome pay. And moreover, this is not Colorado, but a lot of states are starting to legalize marijuana and other drugs too, which if you have a forklift driver, right, you want to be able to drug test them before and after to make sure they're not driving while under the influence, right? But there are now state laws and even some federal laws that prevent you from doing that, which for insurance requirements, it's really tough to meet those. They have their own requirements that you do drug tests and things like that. So there's a lot of liability there from states that are coming up with new rules. And if you agree that drugs should be legalized or marijuana should be legalized, that's fine, but there's a lot of other reform that needs to go into that other than just passing a new feel-good law saying marijuana is okay. You've got to think about the back end of that and the new liabilities and problems that causes too. And a lot of this, like I said, conflicts with federal law, which should preempt it, but states are acting on their own, and this is a terrible problem, especially for those who have businesses across multiple states. And now let me talk about how we're fighting back against all this. How am I doing on time, Bridger? I got a little bit left.
Yeah, you got
Awesome. So that we kind of have three main arms from the legal side of the house at the NAM. It's our Manufacturers Center for Legal Action that I talked about briefly, the MCLA, the Manufacturers Compliance Institute, or MCI, and the Manufacturers Accountability Project, which is our newest initiative. We started it back in November. It's gotten a lot of traction here recently. And a lot of these overlap, but there's a lot of steam behind these, and I think they're really doing great things. So kind of the MCLA, we fight both offense and defense, a lot more defense here as we've seen more of these lawsuits being filed against the federal government. We're stepping in to defend the EPA or defend the DOL or the DOJ. And we're also providing support for our members too in these cases, as well as education and networking resources for Manufacturing Council. And just one example here. So the Department of Justice, they have a division called the ENRD, or the Environment and Natural Resources Division. Just that one division has more than 7,000 active cases right now. And they've only got 450 attorneys and 2 political attorneys overseeing all of that caseload. And there are more cases being filed every day than they can even review. So if you think about those numbers, that's really tough to keep up with. And I was talking to the guy recently who actually heads the ENRD. He spends 1 or 2 days a week just responding to FOIA requests. So take with that kind of a grain of salt, maybe that a lot of these regulations that are coming out are kind of getting under the NGO's skin and forcing them to file FOIA requests is just as one more mechanism, so as a good sign or a bad sign. But that is a lot of cases to keep up with and that are ongoing. And so we step in where we can to try to help push back against that because the government just can't do it all. So just briefly, some of our major wins from last year. We filed 62 briefs. We were a party in 23 cases. Like I said, the overtime rule was overturned, and that had an estimated cost of $24 billion and 25 million hours of paperwork. And again, WOTUS, which was actually an NAM case, National Association of Manufacturers v. Department of Defense, 9-0 Supreme Court wins. So when we can get through the states, through the federal government, and really get into those courts, they are listening, they are pushing back. They see the logic behind a lot of these issues. And the MCI, and I really mentioned this more of as a sample for things you all might want to think about doing for the groups that you work with. We started this a couple years ago, really as a response to members asking us for more help. And this is our Manufacturers Compliance Institute, or MCI. We work on 5 major issue areas, partnering with a lot of big law firms. And through that partnership, we're able to offer free legal information, free compliance, free webinars, free training materials to all of our member companies to help them with all of the many burdens that I was just talking about that they have. We can give them a free discount too if they actually go through and retain those member firms. And it's been very successful. We've actually so far we've helped almost 3,000 people, more than 2,000 companies, and the cost has been $0. And when I say inquiries handled, you might think that 160 is low, but for example, we helped one company that was selling its goods to Vanuatu. And for those who haven't heard, Vanuatu is a small island nation near Australia. I actually learned that while I was working on the case. Or we had one company who found out that they make two-way radios, and its radios had ended up in Germany, which doesn't sound too bad, but the radio frequency that their radios work on in Germany is the military broadcast station. So if you can think about the potential harms there for a U.S. company who didn't sell their radios to Germany, did not intend them to be marketed there, but they ended up there. So just another reminder to kind of be careful about where your products are going and where you are selling them. And finally, this is our newest initiative, the Manufacturers Accountability Project, and we have been hitting this hard. We've hired a person full-time to head this, and MAP is really there to kind of set the record straight and uncover all of these activists who are suing, who are joining together to weaken manufacturers, to weaken companies. And for many years now, special interests have been using tort litigation and politically motivated lawsuits to go after companies, to go after those deep pockets for their special interest. And most of this really is misguided attacks, serving only to undermine both the legal system and then to kind of gain the political popularity of those in government who are bringing them. And again, this is kind of a slippery slope to head down that's hard to recover from later on. So just want to talk about 9 ongoing lawsuits, and I won't go into detail on all of them. There's 8 in California, there's 1 in New York City, and the central issue here is that they are trying to hold energy manufacturers accountable for climate change. So the people who are producing these fossil fuels accountable, not those who are burning and using them. And really, overall, this is a political question, not one that should be decided by the courts. And even though it is a political question, the courts have ruled on it before. And they ruled in Connecticut in AEP which actually ended up in the Supreme Court, that this is a non-justiciable political question that should be reserved for Congress. But yet these trial lawyers keep bringing these lawsuits over and over and over again. And just one example, so they are filing these lawsuits asking for billions of dollars in harm, and the attorneys that are shopping these lawsuits around from county to county and city to city, they're asking for 23% of that fee. So, to me, 23% of a couple billion is not a bad nest egg to retire off of. But we'll see where that goes. So far, they have not won in any of these jurisdictions in any of these cases, but they are gaining headway, and there are a lot more of these cases popping up. Certainly a lot more than we can fight back against alone. And Los Angeles and Colorado are also looking at filing their own lawsuits too, based on these same theories with the same plaintiffs' law firms. So, and just kind of the hypocrisy of all of this, there are two cities in California, Oakland and San Mateo, that are telling the courts one thing and telling their bondholders something else. So a lot of these cities, they issue bonds to help raise revenue. And in these two particular counties, it's been kind of really funny and ironic to uncover. The same person signed both the lawsuit and these bond issuings. I'm just going to read you a couple of quotes here to kind of give you an idea. So in Oakland, the city claims that man-made global warming is an ongoing threat and will accumulate in 66 inches of sea level rise, threatening the local economy with as much as $38 billion in damages. The same person who signed their bond offerings said in those bond offerings that the city cannot predict when seas will rise or other impacts of climate change could occur and whether or if they will have adverse impacts. So $38 billion in damage, we can't predict. That's a little crazy. And we have raised those. We've filed FOIA requests multiple times against all of these cities. We've submitted those to the courts, and the courts are listening, fortunately. Even a lot of the courts in California and in the Ninth Circuit, they're listening to us, and they see how crazy these are. Regardless of where you fall in the climate change debate, the proper way to address that is through Congress, not through the courts. And just to clarify, I get asked about this a lot. The NAM certainly is worried about climate change too, and our members are really leading a lot of the climate change efforts to help address those impacts, both by reducing their impacts and by innovating and coming up with lots of new products to help with that as well. And then San Mateo County, I'll read you that too. They said that there was a 93% chance that it will experience a devastating flood before the year 2050, and that sea level rise could ruin thousands of acres of their land. But in their bond offering, they said that they were unable to predict whether sea level rise or other impacts will harm the city, when they may occur, and whether they will have an impact. And then just want to kind of end here on New York City, which has always been an outlier, but it's becoming even more active here recently. And Mayor de Blasio and others in New York City, same lawsuits, same plaintiffs' firms, and they are targeting not only these companies, but they're also divesting the New York City pension fund from any energy companies. And while on its face that might not sound so bad, but these pension funds are for teachers and firefighters, police officers, and other civil servants of New York City, and the returns on energy investments are higher than almost any other investment right now. So they're really doing a disservice to all those people of New York City by undermining their pension plan for the long term. And just one more point that is kind of points out kind of the hypocrisy of all of this is this past year, New York City used roughly 97% of its electricity was fossil fuels. And they are suing those very companies that are making those fuels to keep New York City running. And oh, by the way, New York City does not like nuclear power plants. It doesn't like windmills. So what else are they going to use, right? I mean, I guess they're going to go to all solar panels. I really don't know. And there are right ways to address all of these things. But suing the people who are providing you those goods and services is really not the way to go about doing it. And I will end there and ask for questions, and I can certainly keep talking if there are no questions. Sure.
When you were saying about the bond issue, the same person signed the bonds, and
Yes.
what about holding some people responsible individually?
Yeah, so that is something we are working on doing. There's certainly huge problems there, not only from an ethics standpoint, but from a fiduciary standpoint. I mean, these are the representatives of the city that are misleading, not only their constituents and the taxpayers, but the bondholders and the courts as well. And those are all efforts we're looking at. If you ask them about that, they'll say, well, I was looking at two separate sets of facts, or I had forgotten what I said, but those are certainly all issues that are out there and that we are right now just working to kind of publicize that. We've run, I think, 50 articles or more right now in different press outlets, and they're really getting traction to kind of address, there's a right way and there's a wrong way. And if you think this is an issue, that's fine, but don't mislead the public in your public statements.
Is that misleading or is that fraud?
I'll stick with misleading for now, but
I think that's part of the problem with the whole judicial system is the counties, the cities, the states all get away with things that nobody holds them accountable for. And it's not going to change unless people are held accountable.
right. That is very true, and a part of kind of our tactic there has been to get these cases out of the state courts and get them into federal court. So a lot of these California cases, the judge just ruled a couple weeks ago that they should be in federal court, so that was hopeful. There's a case in Oregon called Juliana, which is Our Children's Trust, which is a bunch of young people suing the federal government over climate change, and that case right now is in the District of Oregon. The federal government filed a writ of mandamus, which is an effort that they don't typically do, is a very extraordinary effort to try to get that into the Ninth Circuit. The Ninth Circuit actually rejected that, but and again, just kind of the mindset of these plaintiffs is one of my favorite quotes. Actually, is one of the children in Our Children's Trust suing the federal government for climate change. He wants everyone to live on organic llama farms. So, I guess he still wants his cell phone and his car too, but I'm not sure how organic llama farms work out for all the millions of people living in this country.
We've got time for maybe one more question over here.
Yeah, how much are these regulations and regulatory entities influenced by private personal injury lawyers and plaintiffs' lawyers? Because I know it's something that Harold talked about, and then you talked about a lot of the regulatory frameworks and lawsuits. Are a lot of those driven by private entities and private law firms?
So yes, on both fronts. So absolutely, they are being funded by private parties that have given them millions of dollars, from Michael Bloomberg to other groups. And actually, all of these climate lawsuits are from only two law firms who have been trying to. They started out with tobacco, which they were successful in some of those cases, and now they've been shopping around these climate suits, which they've lost every single one of them so far. But when you're asking for billions of dollars in damages, you've just got to win one. And that's kind of the shady under the table part of it, is they are meeting with these cities and counties, giving them a pre-drafted lawsuit and just asking them to sign their name to it, which, maybe the guy who signed both just didn't read the lawsuit before he signed it. But it's very shady, and you would think typically that where plaintiffs groups do smell blood in the water, there would be lots of these law firms picking up the mantle to lead it. And the fact to us that there's only two law firms that are even trying to do this right now really means that there's not as much there as maybe they think there is. All right, well, thank you all very much.